This will be the first video for the civil practice course, and I think I'll be doing two of them. They will both be screenshot videos, and I'm looking at the first posting for the course. Just a few words. Some of you probably were with me last semester. I think I've gotten the sound quality taken care of. The program I use gives me 15-minute increments to do videos. I then route them through YouTube, and I will put them or embed them in the proper place on Blackboard. You don't have to worry about the numbers of the videos, nor do you have to worry about the YouTube channel. It'll just be on Blackboard for you. So let's just get into this first posting and the topic of civil litigation, because that's what the course is about, if you will. The events or procedures followed in civil as opposed to criminal lawsuits. And I've listed in the first few pages, pages 1 and 2, different types of civil lawsuits. And I obviously wanted to give us a sense of the universe of civil lawsuits, but I also want to make a point that the experiences one is going to have in being either an attorney or a paralegal assisting an attorney representing a client in these different types of lawsuits will be vastly different. And what I mean by that is that an attorney is going to approach the representation of a client in a personal injury action far different than a lawyer is going to be representing a client in a divorce action, because the subject matter of the two lawsuits and the tactics and strategies to be followed will just be vastly different. Also, I'm looking at the last two, developers suing local governments. That's going to be a different type of civil litigation than the divorce case, or constitutional litigation. And when I put this together, this posting together, it was before the events of the last presidential election, but certainly there was a lot of constitutional litigation brought unsuccessfully. I think it was about 60 cases that were lost, challenging the results of the election based upon sometimes ridiculous constitutional arguments. But that was constitutional litigation. And shall we say, for the challengers, it was constitutional litigation done poorly. And I say that not as a political person, but as a lawyer. And there were a few times when I paid attention that I was utterly ashamed by the performance of the lawyers. One of the lawyers, who will go unnamed, was asked by a judge about an equal protection argument under the Constitution, and his answer indicated that he was absolutely ignorant of the different standards that courts use to measure equal protection. Standards that when I taught the legal advocacy course, I would have my first year paralegal students master, and this lawyer, I think we could fairly say, was master of nothing, because he couldn't identify the standards. And the two biggest standards are rational basis and strict scrutiny. And he, when the judge said, "Well, what standard do you think I should use?" he said, "The normal standard." So I just was sort of excited by that. But we do have different types of civil cases, and one of the things I'll try to do in giving examples is to use different types of cases for different examples, so we get a feel for that. Also, we're using the Buffalo Creek disaster, a nonfiction book, as one part of the course, and that is a particular type of case where survivors, as I put in the outline of a catastrophic flood caused by the negligence of the mining company, brought a lawsuit to recover for personal injuries and property loss. So that'll give us insight into different types of litigation. What I want to get into next is what I consider to be a very practical aspect of civil litigation, namely how are lawyers getting paid. And so I have a section devoted to attorney fees and civil litigation. And you'll see that I've identified 4 different types of fee. And I also note that the textual outline, which covers this material, is missing one type that I've added here, which is the statutory fee, which I'll get to in a bit. So let's start with the first fee arrangement, which is the hourly fee. The lawyer charges the client X number of dollars per hour for representing the client. Certain kinds of cases give rise to hourly fees. I have like commercial litigation cases and defense attorneys in negligence cases will be charging an hourly fee. What are the plaintiff's attorneys charging in personal injury cases? I'm going to jump over flat fee for a bit and talk about contingent fee. And that's where the lawyer and client agree that the lawyer will receive a set percentage. Typically that's 1/3 of any recovery the client might recover. So in a personal injury case, hurt in a car, what you'll see is that the plaintiff's lawyer is working on this contingent fee. If there's no recovery, then the plaintiff's lawyer gets 1/3 of 0, which is 0. But the defense attorney was actually hired by an insurance company to represent the defendant most of the time will be charging out an hourly fee. What is hourly fee going to be? It's going to depend upon market. Hourly fees in Buffalo, by way of example, are probably greater than hourly fees in Jamestown, but on the other hand, far less than an hourly fee in New York City. That's my strong sense of that. Then, sandwiched between hourly fee and contingent fee is a third type of fee, which is flat fee. And the flat fee is when the lawyer and the client agree that the entire fee will be a set amount. That used to be used in legal clinic type of settings for uncontested divorces, matters like that. What I also wanted to say about a flat fee, and I have it in the outline, is that I'm getting reports from the field from people who are doing, lawyers who are doing some heavy lifting and litigation with large corporate clients, that the corporate clients, in a way to try to cut excessive legal costs, are asking the lawyers to charge flat fees. Obviously, those flat fees would be pretty large, but they're trying to get away, the corporations, from the hourly fees, which at times seem to have no end. So maybe the flat fee will be something that will take on more significance as time goes by. So the next fee I want to talk about is a hybrid fee. I haven't listed that. When I said 4 fees, this is really one I didn't count, but I'm combining it, or if you will, I'm combining a contingent fee and an hourly fee. Where I've seen this used is, let's say, a civil rights type of claim from the plaintiff's lawyer. Maybe there's a claim under the Americans with Disabilities Act. Maybe there's a claim under Title VII of the '64 Civil Rights Act dealing with racial or gender discrimination. But what some lawyers may want to do, of course the client's going to have to agree with this, is combine an hourly fee with a contingent fee. And one way of doing that is the lawyer who wants to have some kind of cash flow coming in on the case might want to charge the client an hourly fee, which which would be an hourly fee less than what the lawyer typically charges, but again, keep some money coming in, and then ask the client to agree to a contingent fee, a percentage of the recovery, which could then be reduced by the hourly fee paid to date. But I've seen, and quite frankly, I have used the hybrid fee setup with some clients in the past. And finally, there's the statutory fee, and the statutory fee means that there's either a state law or a federal law that says in a certain type of lawsuit, one party must pay some or all of the fees of the other party. One example would be a divorce action. I remember running into a lawyer in downtown Buffalo who always wanted to buy me a cup of coffee, and I kidded him one day and I said there's going to be an awful lot of cups of coffee you would have to buy me to come close to the fee that I paid you to represent a former spouse of mine. But he was a good guy, and he did pick up those copies. And in civil rights litigation, the prevailing party for a plaintiff is sometimes awarded counsel fees. So that gives us a sense, and I think paralegals should have a sense of these fees, and oftentimes the paralegals will be charged with keeping track of their time because their time may be somehow factored into the fee. That would be another matter to talk about, but certainly knowing the economic structure of the lawyers you're working with if you're doing litigation, it seems to me is important. And then we have roles of a paralegal in civil litigation, and I have listed any number of things that paralegals can do for lawyers who are representing clients in litigation. Let me just say, as a personal note, I've worked with several paralegals helping me represent clients in litigation, and their assistance has always been substantial. And there was one time, at least with a paralegal in preparing a trial with me, found a forged document that had we put it into evidence would have blown our case out of the water. And I would not have discovered the forged document. His eagle eye did. So, and then just organizing documents. I've had paralegals do legal research for me, subject to my supervision. So I'm a huge fan of paralegals, and I'm a huge fan of how valuable paralegals can be in assisting lawyers with civil litigation. So this will end this posting in a video, and we'll get into more matters in the next video for weeks 1